Should you testify at your impaired driving or your over 80 milligrams of alcohol trial? That's a loaded question. You have a right to remain silent, so you don't have to testify. What happens in an impaired driving trial is winning those cases is often about weakening the police evidence, showing it's not credible or reliable, or showing the police made an error. Oftentimes, the Crown will call the police officers to testify, and I will cross-examine the police officers, and I'm able to show those errors and have the reasonable doubt emerge directly from their evidence with no need to ever call the client. So that's a good situation to be in, and that's always the goal. At the end of the Crown's case, you have to make a decision. Is there enough reasonable doubt based on the police evidence or the civilian evidence? There's civilian evidence often called impaired driving, for the judge to have reasonable doubt. If the answer to that question is yes, you may not want to call your client, particularly when, like, very many of these trials are very technical. It's one on technical aspects, which has nothing to do with what your client's going to say, so you don't have to call them. Now, sometimes when it's an impaired driving and an over 80 case, at the end of the Crown's case, you'll say to yourself, look, I created reasonable doubt in the over 80, but the impaired's still a gray. I think I've done a pretty good job weakening the police evidence, but I think I need my client to bring it home. For example, I was driving down the road, I dropped my cigarette lighter, that's why I was reaching, and I swerved. I had a concussion, here's my medical evidence. So you're dealing with throwing out the impaired, because over 80 is based on technicalities, police mistakes, charter issues. Impaired is based on, is there a reasonable doubt that the accused was impaired? That's a visual thing, so the client often has to testify. So every case is different, but a lot of impaired driving in over 80 cases, I don't have to call my client because a reasonable doubt has been made already, and I know that, and I can see it in the judge's eyes, because some judges actually signal you at the end of the Crown's case, so with subtle questions, Mr. Kruse, do you really want to call your client? That's a nice position to be in. There is the odd judge who will do that rather than waste another half day in court, because we know they're going to acquit. So I often will take a break at the end of the case. I just, in the Crown's case, halfway through the day of the trial day, I will sit down with my client and say, look, these are the pros and cons of testifying. You're fully prepared, but we don't need you to testify, or we need you. And the client, it's the client's decision ultimately, but I guide them to make the right decision. They don't always agree with me, but they usually do, like 99% of the time. I've had the odd client disagree with me, they're too nervous or too much anxiety. That's happened to me before. But that in a nutshell is the answer. The real answer to the question, it depends on the case. It depends if reasonable doubt has already been established at the end of the Crown's case, whether you need to call your client. And it's a tricky decision because you don't want to make the wrong decision, because if you think the judge is going to acquit, don't call your client and he convicts, wow, you made the wrong decision. So that's why you need to prepare that client, and you tend to err on the side of caution by calling your client, unless you're compellingly convinced you've already won the case at the end of the Crown's case. That's it in a nutshell. Thank you for joining me today. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.